Hi folks, welcome to the quick intro to workshop number 7. Sorry, no slides this week. Just you're going to have to deal with my ugly mug. And this week we're looking at the workshop on genetic patents. And particularly the scope of this workshop is also to look at the role of the lawyer in the political process, and particularly the role in drafting parliamentary speeches. And this is not an uncommon role for lawyers to find themselves in, not necessarily for ministers, but for senior bureaucrats when you're working in the public sector, particularly as a young recent graduate. And it's something that we don't often foreground as a career skill in the law program, but it's something that's very important. And it's something you may well find you're doing if you're working in government. Being able to translate a complicated legal set of policies into something which is quite straightforward and easy enough for a politician to deliver, and to deliver in a convincing way as well. So this week we're dealing with the rather hot topic of the patenting of life forms, particularly the patenting of genetically engineered life forms and the issues around stem cells. And one caution I would start with is it's very easy to get swamped by the non-legal parts of this argument. So the ethical and moral issues here are very, very interesting. I'm not denying that. But when it comes to preparing an argument on the legal aspects of it, it can be very easy to get swept away with the other aspects. So the first thing I would recommend that you do is, even if you draw up 2 columns on the page, legal on one side, moral, ethical on the other, and start thinking about the differences there. So there's the question of whether you can legally patent these life forms, the consequences of that. And on the other side, there are the questions of should or shouldn't. And those might be persuasive things you might want to allude to. But given the length of the speech, given the amount of time you have available, it really is important to focus on the legal aspects. And as a reflective exercise, it's, I guess, also important just to think about how in our work life we separate those things. How are they separate? Why are they different? What problems come from trying to separate those? And I would refer you also back to the reading from Chen from last week. He makes some good points to think about in terms of, makes it in a slightly bizarre and confusing way, but the difference between patenting of information and the patenting of the thing that the information is attached to. And here's a clear indication of a situation where we need to think about what is the difference of patenting a genetic enhancement, particularly a transhuman one that might one day be an enhancement that a human being has, patenting the process, patenting the genetic aspects of it, and patenting and owning the person that it's attached to. And there's separate issues that need to be teased out. And I think you will be all too familiar with one of the core themes of our course, which is that confusion about when you start using the property metaphor and property doesn't quite apply. And here's a situation where you start looking at personhood and property, and it starts becoming quite, are we looking at some form of slavery? And we're not, but you can see why there are those sensitivities around that. So I think that the material and the topic and the theme is very interesting for this week. It's something which has an interesting kind of sci-fi bent to it, but it's one of those things that, today's science fiction, tomorrow who knows. And we're seeing different approaches emerging around the world as to what we do about that issue of transgenic organisms, and particularly transhuman organisms. What are we going to put some firm boundaries and say, no, human is human? This is something that we shouldn't. Not only shouldn't we do, but we shouldn't use the patents process to reward innovation in that area. Or is that kind of a medieval approach? Is that an anti-scientific, backward-looking approach? Or then again, is the scientific approach kind of part of that world of solar science that we should all be alarmed about? Anyway, so the recommendations for this week is to bear in mind that the difference between the big theme, the big Frankenstein theme of what will happen once we start messing with the human genome, and the actual intellectual property aspects of what about these particular aspects. So have a look at the stem cell debate, have a look at what's happened with the breast cancer decision recently, and then look at how you can put those together into a persuasive argument that draws on all that legal knowledge but delivers it in a way which is persuasive to people who may not have that legal background. Okay.